Hello, this presentation is one of a series describing the changes to civil procedure in England and Wales as a result of the Jackson reforms which came into force on the 1st of April 2013. Some of the other presentations supply the detail. This one's designed to give an overview of the litigation process from pre-action to assessment of costs following trial. First of all, pre-action and funding. Now, changes to the funding arrangements are central to the Jackson reforms. When it comes to conditional fee agreements, the success fee in personal injury cases is subject to two limits. First, the existing maximum of 100% of base costs will continue to apply, but secondly, there is a new cap of 25% of damages, excluding damages for future care and loss. Now, this 25% cap includes a solicitor's success fee, any barrister's success fee, and VAT. Next, damages-based agreements. The Act now allows the use of damages-based agreements, or DBAs, in all areas of civil litigation. Once again, there will be a 25% cap on the amount of damages, excluding damages for future care and loss, that can be taken as the lawyer's fee under a DBA in personal injury cases. Now, that compares with the cap of 35% on damages in employment tribunal cases, and there's a general cap of 50% on damages in all other cases, that is to say, other than personal injury and employment cases. Now, one of the biggest changes to funding concerns the recoverability of success uplifts and premiums paid to secure the after the event insurance cover, which covers the risk of having to pay the other side's costs. Neither the uplift nor the premium is recoverable under the new rules in respect of cases begun after the 1st of April 2013. Now, the new rules don't directly impact on protocol pre-action requirements or the question whether the parties should consider attending a mediation at the pre-action stage, and neither do they touch on pleading the particulars of claim. Following through the litigation process, we now reach the stage of issuing a claim form and service. So, when it comes to preparing the claim form, preparing particulars of claims, issuing the claim form and serving the claim form and the response pack with the particulars of claim, none of those are affected by the reforms, and so we move on to the stage of filing and service of a defence and perhaps a counterclaim, and once again those things aren't affected by the new rules, although it must be said that the filing of the defence does prompt new case management activity on the part of the court. So, after filing a defence, the court first of all provisionally allocates the case to a track, that is only a provisional allocation. The court then serves on each party a notice of the proposed allocation, and it also requires the parties to file a directions questionnaire. In addition to a directions questionnaire, the parties will be required to file their proposed directions by a specified date, so long as the case has been provisionally allocated to the fast track or the multi-track. Moving on to case management and the parties' response to the notice of proposed allocation. Now, parties, as a response to the notice, must file completed directions questionnaires and proposed directions by a specified date. Now, the rules provide that in a multi-track case, that specified date has to be at least 28 days on from the deemed arrival of the directions questionnaire. Now, continuing with case management, the next question is, should a party seek a stay? Now, if all of the parties to the litigation do ask for a stay, then, as it were, as of right, the parties will receive a 1 month stay, for instance, if the parties want to attempt settlement by mediation. If the parties don't all agree to a stay, the court can, nevertheless, determine that a stay for 1 month is appropriate, or indeed for such other period as it considers appropriate. Very often for mediation, 28 days or 1 month is not enough. Now, we move to allocation. Having previously made a provisional allocation, the court now allocates the case to a track after receipt of all of the directions questionnaires, and it will generally go on to fix a case management conference. Next, one of the innovations in the new rules, at least 14 days before the first CMC, each party has to file and serve a disclosure report. Now, a disclosure report must briefly describe what relevant documents exist, where they are and say how electronic documents are stored, and must also provide an estimate of the cost of giving standard disclosure. At least 14 days before the first CMC, once again, if an electronic documents questionnaire has been exchanged, that questionnaire has to be filed with the disclosure report. Costs budgets. At least 7 days before the first CMC, each party must file and exchange its costs budget. Now, this applies to Chancery Division cases under £2 million and generally Queen's Bench Division cases, but it does not apply in Admiralty and the commercial courts. Now, before the case management conference date, if any, the parties have to attempt to agree appropriate directions, and at least 7 days before any CMC, they must submit their agreed directions or their respective proposals, if they've been unsuccessful in agreeing, to the court. Now, the case management conference will be vacated in certain circumstances. That is to say, first of all, if the court approves the agreed directions, or whether or not there are agreed directions, if the court issues its own directions, and otherwise the CMC will take place on the notified date. Now, at any stage, the court can make a costs management order, which will do the following. It will record the extent of any agreed budgets and record the court's approval of any agreed budgets or its approval of any non-agreed budgets. Now, the effect of a costs management order is this. The court now controls the parties' budgets, in that case, in respect of recoverable costs. Next, when it comes to directions, the court has regard to any available budgets, and that is so whether those budgets have manifested themselves into a cost management order or not. Now, standard directions, which will be available online, will generally be made in the place of the previous ad hoc arrangements by which case management judges had their own preferred directions in their top drawer. And when it comes to directions, first of all, disclosure orders will be taken from the new disclosure menu. Now, that menu comprises these possible disclosure orders. First of all, that there should be no disclosure. Secondly, that the parties should disclose just those documents they rely upon, and also make specific disclosure requests of each other. Next, the court can make an order for issue-by-issue disclosure. Next, the court could make what is generally known by practitioners as a Peruvian guano disclosure order, which is explained in the disclosure presentation that goes alongside this presentation. Next, the court could order standard disclosure. And finally, the court could order some other form of disclosure. Now, when it comes to directions for witnesses of fact, a direction can be made identifying or limiting the issues to which evidence of fact can be directed. A direction can identify the witnesses who may be called or whose evidence may be read, or the court can limit the length or format of witness statements. When it comes to directions for expert evidence, the parties must provide an estimate of the costs of the proposed expert evidence that they seek to call, and the order may specify the issues to which the expert evidence should address. And lastly, a new innovation, having been trialled elsewhere, the order may direct that some or all of the experts from like disciplines give their evidence concurrently, or a hot tubbing order as it is known. Next, is the question of costs management conferences. Now, the court can convene a costs management conference at any time, and the purpose of such a thing would be to approve revised budgets. Now, where practicable, cost management conferences should take place by telephone or in writing and not involve a live hearing. Now, we reach the stage of the trial. When it comes to trial, the Jackson reforms generally do impact on the relief that the substantive relief that the court can order, because alongside the Jackson reforms, and part of them, the Court of Appeal in Simmons and Castle has made an order that there should be a general 10% uplift in general damages from now on to compensate claimants for the loss of the recoverability of CA uplifts and ATE insurance premiums. Now, when it comes to the costs orders that are available to a judge, well, in the event that a successful defendant's Part 36 offer has been made, there's no change here. The claimant will pay the defendant's costs on the standard basis plus normal interest on those costs from the last date on which the offer could have been accepted. But when it comes to the costs orders available following a successful claimant's Part 36 offer, the court has more in its locker. First of all, as the existing rules provide, the defendant can be ordered to pay the claimant's costs on an indemnity basis from the last date for acceptance. Secondly, the defendant can be ordered to pay enhanced interest on the principal sum recovered. And thirdly, the defendant can be ordered to pay enhanced interest on the costs. Now, those are all part of the pre-April 2013 Part 36. But in addition to that, the Jackson reforms have added a fourth prize available to successful claimants having made Part 36 offers, and that is that the court can order an additional 10% on top of the debt or damages as a prize for having made a well-judged Part 36 offer. Now, where the claim is not a money claim, that prize obviously can't be awarded because there is no debt or damages to add the 10% to, and in that sort of claim an extra 10% will be added onto the costs. Now, when it comes to assessment of costs, if a cost management order has been made, then on a standard basis assessment, the court will have regard to the receiving party's last approved or agreed budget, and it will not depart from that approved or agreed budget unless the court is satisfied, the costs judge is satisfied, that there is good reason to do so. And lastly, just to remind you that on an assessment of costs, the success uplift on a CFA or a DBA is not recoverable, and neither is an ATE insurance premium recoverable. So that concludes this short review of litigation procedures since April 2013. Thank you.